Welcome to this 2TG Common Law Group seminar on the impact of statutory duties on an employer's duty of care. I'm Niazi Fetto, and I'm going to be talking about cases in which we have concurrent duties applicable to a set of facts in an employer's liability claim. By concurrent duties, I mean duties arising under statute, under health and safety regulations, under the Health and Safety at Work Act 1974, and the employer's ordinary common law, contractual and tortious duty of care to its employees. And in those situations, a situation that we're very familiar with, since reforms that happened in 2013, we're faced with a question, which is how do the statutory duties affect the common law duty? We all know that in 2013 the law changed. Section 47 of the Health and Safety at Work Act was amended, and there ceased to be a direct action for breach of statutory duty in employers' liability claims, or under the Health and Safety at Work Act and regulations made under it. So where does that leave the common law duty? We've got various possibilities, and the law remains unsettled today. One possibility, for example, is that we should just ignore the regulations and legislation, put them to one side and apply the principles of common law negligence without any reference to them. Another possibility is that the regulations in some way influence the duty and standard of care in the employer's liability context. And then, of course, the question is, well, in what way? A further possibility is that the regulations, the legislation, effectively is coterminous with the common law duty of care. So the common law duty expands so that it effectively gives rise to the same principles, to the same rules that would apply if the legislation remained directly actionable. I'm happy to spoil things a little bit by saying that I think probably the second of those options is closest to where we are. We don't have very much we have no appellate authority, in fact, and we have only a few, mostly not altogether satisfactory first instance decisions in the area. So there is a good deal of clarification yet to come from the courts, when, of course, we don't know. Let's have a look briefly at Section 47 itself. And on the slide you see the before and the after. So this is before and after the passing of the Enterprise and Regulatory Reform Act in 2013. And so before the 1st of October 2013, when that act came into force, you could bring an action, a civil action, for damages under the act, under regulations made under it, typically the six-pack regulations. And that action was an ordinary action for breach of statutory duty, actionable as set out in Section 47.2. That was directly actionable as set out in Section 47.2. And what happened as a result of the Enterprise and Regulatory Reform Act was that from the 1st of October 2013, the wording was essentially the same, although repeated for different contexts, but with the addition of the vital word not. So we went from things being actionable under the Act to not being actionable, which on its face seems straightforward, and indeed it is straightforward, but the question is how that then impacts on the common law position. In order to properly understand and approach that question, I think it's important to do a bit of mining into the history of the cohabitation of common law duties and statutory duties, especially in this context. And you'll see on the slide a quotation from Lord Tucker in a 1950s case, Latimer and AEC, not one that we are regularly citing these days, but one which gives us an important principle, which is that these are two entirely separate streams and sources of law. So Lord Tucker was concerned, and it seems perhaps a little surprising to us these days, given what's happened on the statute book since the 1950s, Lord Tucker was concerned that there would be an expansion of the common law to encompass the so many statutes and statutory regulations imposing absolute obligations upon employers back in those days. And his concern was that that was wrong. It was wrong to expand the common law duty so that it subsumed and replicated the statutory obligations imposed upon employers, especially those that were strict, or in his terms, absolute. A further important question which we need to research in the history, and which I find to my surprise is often got wrong or addressed wrongly by professional colleagues, not in these chambers, I hasten to add, is what is the common law duty? And the answer is simple. It starts with what Lord Wright said in Wilson's and Clyde Cole, which you see on your screen now. It is simply to take reasonable care for the safety of the workforce. That is the encapsulation of the employer's duty. Now, what is reasonable care is the next question, and that has been settled also for a very long time. I've picked the often quoted dictum of Mr. Justice Stanek in Stokes and Guest, Keene and Nettlefold, Bolts and Nuts Limited, which gave some insights into what is reasonable care, and which was famously the source used by Lady Justice Hale, as she then was, in Hatton and Sutherland, Barber and Somerset, when looking at what duties applied, what the correct interpretation was of the common law duty of care in the context of stress at work claims. And what Mr. Justice Stanek said was that the employer has to take positive thought for the safety of his workers in light of what he knows and ought to know. And additionally, the employer has to weigh up the risks in terms of likelihood of injury occurring and potential consequences if it does, and balance against that the probable effectiveness of the precautions that can be taken to meet it and the expense and inconvenience they involve. So that, in simple terms, simple settled terms, is the common law duty, standing separately, entirely separately, not dependent in any way upon statutory duties which have arrived since. And so now we need to look at what Parliament intended when it changed the wording of Section 47. I've put up on the screen a quotation from Matt Hancock, for it was he who presented the bill, the Enterprise and Regulatory Reform Bill, to Parliament back in late 2012. And whilst there was an awful lot of debate in both houses about this change, I've included that quotation particularly because it refers to a report that the government had commissioned and upon which it relied in presenting and introducing these changes. And that was a report by Professor Löfstedt, which, as you see, Matt Hancock said, who Matt Hancock had said had considered the impact that the perception of a compensation culture has had in driving over-compliance with health and safety at work regulations. And that's a little bit word salady, as is the entire quote. But the point that we need to take from it is that this wasn't a reform that came out of thin air or from a focus group within the government at the time, but it drew on research that had been done and a report prepared by Professor Löfstedt. So we can get some clues as to what Parliament intended, what the point of this reform is, by looking at that report, which is something that I have done. And I've put up on the screen the conclusions that Professor Löfstedt reached. His report is called Reclaiming Health and Safety for All. It was prepared in November 2011. And as I say, it's just the conclusions that I have put on the slide. And Professor Löfstedt was worried that regulatory requirements were being misunderstood and were being inappropriately applied, as he puts it, and recommended various changes to address those problems. you'll see immediately that out of the three bullets that follow, A, B, and C, A and B don't apply to what was being done in amending Section 47 of the Health and Safety at Work Act. But C does. So at C, Professor Løvsted says that there needs to be a rebalancing of the civil justice system by clarifying the status of pre-action protocols and reviewing strict liability provisions. Pre-action protocols aren't dealt with by Section 47, but of course, strict liability under health and safety legislation was fairly and squarely hit hard by the amendments that were made. Just before we come to that, I should mention briefly what the comment about pre-action protocols refers to. The concern that Professor Løvsted had, and which was aired by the government presenting the bill in the Commons, was that at the pre-action stage, in the employer's liability context, what the employer is sent with a letter of claim is a list of disclosure. There is, of course, an obligation under the pre-action protocols to provide very full disclosure. And the worry that Professor Løvsted had was that that was a very demanding list of employers, particularly small employers, firstly. And secondly, that many employers, when they realised that they couldn't produce every document sought, or that they hadn't properly completed or kept up to date some or all of the documentation requested, would immediately think that they were sunk, that because they had breached the rules or requirements or guidelines that meant they should have had that documentation available, then their defence of the claim was doomed. So that was pre-action protocols. But coming back to Section 47 and how this report influenced it, there we're looking at strict liability. That was the concern in the Professor Løvsted report that Section 47 was addressing. But what didn't happen in the Enterprise and Regulatory Reform Act, or thereby, was any sort of review of strict liability provisions. Rather, what happened was that the government and Parliament ultimately used a much blunter instrument than that. What they did was they removed the application of all health and safety legislation, save where, or save only to the extent that, negligence could be proven. So, without succeeding in your negligence claim, the claim would not result in recoverable damages. Now that clearly doesn't just impact strict liability, but strict liability was the target. And I expect anyone watching this would be able to guess which was the example case cited by Professor Løvsted when expressing concern about strict liability. It was, of course, Stark and the Post Office, the famous case in 2000 in which a postman brought a claim because he'd been injured by his bicycle was defective, and it was a matter of record. It was a fact that the defect was not evident and could not, with reasonable care, have been identified by the employer. But nevertheless, Mr. Stark recovered because his bicycle was not effective work equipment for the purposes of the provision and use of work equipment regulations. And that meant that the employer was strictly liable. And it was that was the target of the Professor Løvsted report, or that part of it, and it was that which was a principal target of the reform to Section 47 of the Health and Safety at Work Act. With that knowledge, the next thing that I think we need to do is to look at decided cases under the amended provision. Having looked at Professor Løvsted's conclusions, the next thing we should do is look at how the courts have interpreted Section 47.2 insofar as they have had opportunity to consider it. And you'll see on your slide two cases, both of which have their unsatisfactory features before we even get to what the judges said about Section 47.2. The case of Cockrell was first in time, a decision of Mrs. Justice Collins Rice, but it was a decision that was reached, at least on this point, without full argument because the parties had agreed the position. They'd agreed the effect of Section 47.2 for the purposes of the facts of that case. And Mrs. Justice Collins Rice was concerned that that sort of agreement shouldn't pass without some comment, and so made the comments that I have quoted on the slide. One of the things that Mrs. Justice Collins Rice observed was that the legislation remains binding. So all of the provisions that remain in force of the Health and Safety at Work Act and all of the regulations made under it remain binding in just the same way that they were binding before the 2013 reform. And indeed in the criminal law, they are not just binding but fully enforceable. It's just the recoverability of damages for breach of those provisions which has been affected by the changed wording of Section 47. And so because they were binding, because they're still there, they still bind the employer and they still are enforceable under the criminal law, they were, as Mrs. Justice Collins Rice put it, relevant to the question of what an employer ought reasonably to do. However, Section 47.2 had effected a rebalancing, which was evidently directed to ensuring that any breach of statutory duties would be actionable by claimants if, but only if, it also amounted to breach of a duty of care owed to a particular claimant in any given circumstances. Or in other words, if the breach itself was negligent. Notice that Mrs. Justice Collins Rice used the word rebalancing, which is the word that Professor Loefstedt used when talking about the civil justice aspects, civil justice reform aspects of the Enterprise and Regulatory Reform Act as it then became, but within his report it was his recommendation. So what Mrs. Justice Collins Rice concluded was that we have a sort of double actionability situation or something approaching it, whereby you apply the regulations, you look at what is binding and the terms of those regulations, but they're not enforceable except to the extent that the claimant can go on to prove that the employer has been negligent. What we don't get from the Cockrell case is any guidance on how the regulations are relevant to the question of what an employer ought reasonably to do. So how they inform that standard. Then later that year was the case of Tonkins, a decision of His Honour Judge Alan Gore QC, as he then was, and he disagreed strongly with that approach and that interpretation of the new wording of Section 47.2. In Tompkins he said, and again this is unsatisfactory because it was all entirely obiter, if that had been the intention, Parliament would instead have chosen to repeal the statutory duties in question. I would not have been prepared to find, without much more analysis and argument, that the effect of Section 47.2 was to deprive an accident victim of entitlement to rely upon a finding that breach of statutory duty constituted ipso facto negligence, even if no civil right of action was available for its breach. Now, the judge didn't hear full argument, but the difference between his position and Mrs. Justice Collins Rice's is plain to be seen. His Honour Judge Alan Gore was not willing to countenance, at least without further argument, the possibility that there could have been a dilution of the standards imposed by health and safety legislation by the insertion of those nots into Section 47, despite their apparent plain meaning. So removing actionability, to his mind, seems to have simply shifted the same obligations into the actionable cause of action, which is negligence. Well, both those cases were then considered, much more recently, by Simon Tinkler, sitting as a Deputy High Court judge in the case of Chadwick and R.H. Ovenden Limited. And he came down on the side of Mrs. Justice Collins Rice's analysis, finding a couple of difficulties with His Honour Judge Gore's. And he said, it doesn't seem to me correct to say that a breach of statutory duty under health and safety regulations will, after the 2013 reforms, automatically constitute negligence. pointing out, of course, that the very thing that Section 69 of the 2013 Act did in amending Section 47 was to remove the automatic link between a breach of the regulations and the right to claim damages. The most obvious situation where this occurs, he went on, is where a regulation provided for strict liability for non-negligent breaches. And here we are back in the territory that Professor Löfstedt wanted to address in his report. Strict liability is the target. Following the 2013 reforms, there is no claim in such a situation. That is a change that the 2013 reforms put into effect. Parliament has not, on the other hand, legislated to remove or amend the common law liability of a person for negligence. So where does that leave us? And how does this change, how does the remaining binding legislation affect, if at all, the common law duties of the employer? Well, the first thing we have to bear in mind is that Parliament's principal target seems to have been strict liability for breach of health and safety standards. So the interpretation of Section 47 is that it must at least, the correct interpretation is that it must at least do that. It must at least pull strict liability out of the picture. And the mechanism by which it's done that is blunt. It is to limit recoverability of damages to situations where, and only where, negligence is established. So Parliament is effectively saying fault must be shown, and the way that you do that is not by reference to the legislation, at least not principally, but common law negligence. And here we come back to where we started, which is what that common law duty is and how you find its scope in any particular case. We come back to the fact that it is a standard of reasonable care, and that is the standard that must be borne in mind at all times. But also, as Mr. Justice Stanek said in the Stokes case, it's also the case that that obligation to take reasonable care requires positive thought on the part of the employer, takes into account not just what the employer knows, but what he ought to know. And it involves a positive obligation to weigh the relevant risks, which of course must entail making the employer making himself aware of those risks. And that is where the legislation comes in. So it's not a question of applying the legislation across, bringing its substance into the common law duty, but rather the fact that there is legislation in force on the facts of any employer's liability claim means that the employer must be taken to know. He must be imputed with knowledge of the terms of that legislation, especially if it's enforceable in the criminal context, but even if it's not. And that must inform the employer's positive obligations. That must inform what the employer must take into account when considering what the risks are and what the balancing exercise is between the gravity of the risks in the context of the facts of the case and the measures needed to address it. And that's my take on it. And I'm happy that it lines up with at least the latest decision, the only decision really to have heard full argument on the point at first instance. But that is for the time being. And we shall have to see in due course what an appellate court makes of this territory.